We're live.
All right, welcome everybody to House Energy and Digital Infrastructure. It's Wednesday, January 28th, and we are wrapping up testimony on H527. And today we've invited Will Dodge, who is a managing partner at Downs Racklin Martin and who has extensive experience with telecom tower siting. So we'll go around the room and introduce ourselves, including folks who are here as guests, and then we'll turn it over to you and you can introduce yourself for the record. So we have our next testimony scheduled at 10. We're a question asking committee, so I'm learning I need to flag the time at the outset. So I'm Representative Kathleen James from the Bennington 4 District.
Scott Campbell from St. Cosbury.
Richard Bailey from Mobile 2.
Chris Morrow, Wyndham, Windsor, Bennington. Michael Southworth, Caledonia 2. Christopher Howland, Rutland 4.
Dara Torrey, Washington 2.
Graham Klipner, Chittenden 13, Burlington.
Right, and
Claire Buckley, Leader 9 Public Affairs for CTIA.
great.
Dana Lee Perry with the Crassen Group.
John Brabant, Vermont District Environment. Morning, well.
All right. For the record.
Well, so good morning. Thank you for the honor of appearing before your committee regarding H527. My name is Will Dodge, and as you said, I'm the managing partner at Downs Racklin Martin, where the bulk of my legal work over the past 25 years have been related to telecommunications siting in Vermont and New Hampshire. I support avoiding expiration of Section 248A as envisioned by H527 for the simple reason that requiring telecommunications infrastructure projects to undergo review under Act 250 and local zoning is not in the best interest of Vermonters who need reliable wireless internet and phone service for public safety, for navigation, for commerce, for recreation, and for interpersonal communications. I make this statement from experience, having seen wireless infrastructure in Vermont dramatically improve since the second iteration of Section 248A was passed in 2009, and especially in comparison to where things stood prior to that date, and also based on my comparative experience looking at New Hampshire. So the Public Utility Commission representative who testified before you characterized, I think he said that roughly 90% of Section 248A projects undergo review without controversy or friction. And I think yesterday I heard the testimony from Hunter Thompson at the department saying, well, they think it's more like 85%. And I would say either one is probably 87.5. So I would agree and would point out that most of that work represents network modifications to existing facilities. And those modifications are vital for ensuring that Vermonters enjoy reliable state-of-the-art technology from a broad array of communications providers. And in that respect, Section 248A is one of the most predictable permitting programs in Vermont. So I can tell my clients exactly, or with a high level of certainty, exactly what's required to proceed, exactly what will happen during the review process, and I can attest to the expertise of those at the Department of Public Service and the Public Utility Commission conducting that review. And most importantly of all, I can let them know by when the process will be concluded, whether it's an approval or a denial, and assure them that no additional process is needed in order to install equipment. So that level of certainty and that sort of functionality in the process is worth preserving for those network modifications. Now, that other roughly, let's call it 12.5% of Section 248A projects that involve new towers or tower replacements, as well as small cell sites involving attachments to either new utility poles or more often than not replaced utility poles, are sort of take a lot more work. And I won't characterize that latter bucket as functioning anywhere near as smoothly as the modification projects, which I'm sure I know that you've all heard about that. And I'm cognizant that there's many out there who feel that there's elements of the process that are flawed or are unfair. There's no question that improvements to the Section 248 process are warranted for those towers and the small cell projects. And it's my belief that the sunset provision in Section 248I has been an impediment for the commission to improve this facet of the siting process. And that by either repealing the sunset or creating a longer time period before that sunset, before the next sunset, would prove sufficient for the commission to convene a full workshop with stakeholders to issue a new standards and procedures order or to conduct a rulemaking. Yet, even if H 527 were to pass as is with a 3-year extension, the law is vastly preferable to the alternative. And that alternative involves going back to the state of affairs that we had in 2008, when telecommunications projects were governed both by Act 250 and municipal planning and zoning. There's several reasons, and I put this in my testimony, so I don't think I'll go through it all unless you'd like me to, but there's several reasons why, both on the Act 250 side and on the municipal side, there would be real problems or real setbacks that I think are far worse than the other problems that have been identified with the Section 248A process.
I mean, unless you don't think you don't have time, I wouldn't mind, having that discussion.
Walk through those? Okay.
Yeah, I mean, we've received voluminous amounts of public testimony, and I want to make sure that we,
Sure.
it's
So I'll go
We're
through it
drowning.
at kind of a high level, and I just want to make sure that given the time that we've got time for questions.
yeah. Oh, sorry, Rep
Yeah.
Daly.
Just wanted to ask, have you actually done an Act 250 case?
Yes. And in fact, one of the things that I think is difficult to see with this whole process, you've had a lot of testimony about how many cases go through Section 248 from beginning to end and how they come out. And I would say two sort of categories of citing cases that you don't see are, first of all, the cases that start as a 248A petition, but actually never even go far enough in the process and get pulled due to problems and due to reactions by whoever is doing the citing. And that's a more significant number than is commonly understood. And then the other category is sites where, for any number of reasons, a decision is made by whoever the developer is or whoever their attorney is to do a combination of Act 250 and local, just because of the particular circumstance. I'll say that I have done that many times. I would say that more times than not, as soon as I do it, or as soon as we're done that Act 250 local process, I regret it and say, we should have just done Section 248A. That would have been a better process. But we have done it, and we've done it recently. And that includes taking cases all the way through to the environmental court, where we'll spend a week litigating in a courtroom over a tower case, and with the possibility that that then goes to the Vermont Supreme Court. So just walking through some of the issue that I would be concerned about with Act 250, or having everything revert to Act 250. One, and maybe the most important, is the lack of expertise. Unlike the Department of Public Service, which has experts familiar with the technology, familiar with the state telecommunications plan, and telecom-specific legal standards, the district environmental coordinators lack any expertise in telecommunications, as do most of the volunteers on the district environmental commissions. So right out of the gate, you are basically going from a system that at least has professionals who understand what they should be looking at, to going to where you have to reinvent sort of the knowledge base from scratch. Another, I would say, equally important consideration is what I call the restricted criteria. So Act 250 really is limited to consideration of environmental impacts of a project without any consideration of public benefits, such as improved coverage or improved capacity, increased competition among providers, safety, public safety. So that includes things like making sure that a carrier is meeting the RF emission standards, or as you heard Mr. Thompson testify on yesterday, making sure that a structural report, somebody actually knows how to read it to know whether a tower is in fact capable of accommodating new antennas or new equipment on it. The Act 250 doesn't have any of that type of any criteria that's directed at those specific concerns. Section 248A requires a balancing among the public good and the environmental considerations. And we think that at its base, when it works well, works really well. I won't say it's always going to work. And I think that goes back to the questions about the stakeholder process. The third concern that I have is kind of the lack of administrative experience. So right now, if we started putting all of our applications like we did last year, I think Mr. Thompson said last year, 175 different applications went through the PUC system. We're very concerned that the system of the district coordinators and the LURB, plus all the municipalities, are just not equipped to take on that level of volume of applications. And that's evidenced to some degree by the fact that Act 250 used to have a telecommunications form to fill out to try to do projects. It was very voluminous, but it was what was used. That form is no longer even available and hasn't been touched for over 12 years at least. We're also concerned, and we saw this back in at least the sort of 1996 to 2008 period, that you can often end up with very different results among each of the district environmental commissions. So they're not administering the statute the same way in similar cases. With Section 248A, we at least have that uniformity across the state, which is really more important when you're thinking about making network-wide upgrades or deploying new technologies across the whole state. Another concern that we have is that the way Act 250 works is what I call the elongation of the review process. So Act 250 typically will not even start to look at your Act 250 application until your local permitting process is completely concluded. And so that means that the overall amount of time to go through permitting from beginning to end ends up being substantially longer, especially if there's more taking place at the municipal level. And I'll talk about that in a minute. And I realize that there's probably some conflicting testimony on this, but my sense of it is that what 248A provides, again, when it's working well, 248, the energy siting statute has always been characterized by the Supreme Court and by the Public Utility Commission as a quasi-legislative process. So in other words, supposed to be less like a court case and more like a community case where you're building something together, you're taking testimony, and you're modifying it as you go along. When the system works well, it's proven to be a much better vehicle for fashioning conditions in a given situation. And that's especially so, again, going back to the role of the department, of having a public advocate who's looking out and trying to achieve settlements or make sure that the truth about a particular application is coming out. And so the department works very close with us on getting settlements that are based on environmental concerns, based on aesthetic concerns, based on public safety concerns. And I could give a number of examples, but just two that come to mind. One was when AT&T was having a lot of trouble finding an appropriate location in Thetford, and really in the Thetford Corners area, and actually looked at multiple different candidates. But when we were working with the town identified and said, well, what about your town? What about our town forest? And that way the town will get some of the revenue from the tower, but also it's a good location and most people aren't going to see it. We said, that's great, but we immediately ran into a problem of, well, there's some environmentally sensitive conditions there. And what we ended up working through with a combination of A&R, the department, the town, and in this case, the Upper Valley Land Trust, was a situation where we built the tower on the town forest, but we preserved half the forest through a land grant, so that basically what you came out with, all memorialized in the CPG, was a situation where we reduced the aesthetics, we enhanced the environmental considerations, and we got a site that actually works and is providing good coverage in Thetford. Another example, just again, goes to the town of Stowe. And this is a much smaller example, but it involved a pole that was located on the corner of Depot Street in the downtown village. AT&T wanted to do a small cell site, right? So one of those canister antennas that I know that you guys have been talking about. There was a real concern about it because on that lot, there was, it was basically what we thought was a parking lot, but what turned out to be an area that was going to be slated for new residential development. And it was in an area where the electrical situation was, let's just say, not pretty. There were wires going all over the place, secondary lines going over to a house. So what, and there was a concern that if we just simply put another pole that looks like the existing, not so pretty looking pole, it was going to affect the aesthetics of what was a real plan for that section of the village. So what AT&T did, and it took a long time and it required going through, several facets of the 248A process, was to ultimately underground certain of the lines that were in the area, including across the road, build what is essentially a black 45-foot monopole, but a monopole that has the same ornate lamp on it that is used in that area of the town, and did so in a way that we provided a transformer right on the property where the developer was ultimately going to build their new facility. And this has all happened in the past, certainly in the past 5 years, but there's multiple examples where that flexibility of being able to work out a solution works out much, much better in the 248A system than if you're trying to do that completely at the municipal and Act 250 level. So maybe I should stop there. I can talk about the problems with the municipal process, but I realize I'm fire hosing you with a lot of information. And I want to see if there's some questions.
Good.
That was a great overview right there. Actually, I guess I can't think of a question yet, but I am looking forward to hearing about the municipal issues too. So this was just an overview of the problems with the Act 250 process as opposed to 248.
Correct. And I wish that were it. I mean, as one of these things where I wrote my testimony as I was driving down here, I was thinking, oh, and there's also this problem and that problem. The one other one that I wish that I had put in my written testimony, but I'll just mention here, that has to do with the polls. And I recognize that yesterday, I think someone in the committee identified that, or maybe it was Mr. Thompson said that, well, Verizon is using Act 250 to do these poll sites. And that may be true. It's possible that for whatever reason, a decision was made by, a particular carrier that Act 250 works better. My concern about that, though, thinking back to Shelburne, is that in many cases, what looks like it might be easier under Act 250 doesn't take into account of, well, do you also need a municipal telecommunications permit for that small cell site that's going on a pole? And if you read most definitions of most ordinances in most towns, they will end up covering that small cell site as though it's I think what Mr. Thompson referred to as a macro site, right? Much more like a large cell tower with a whole different set of rules and requirements that really don't honestly make much sense for a small cell site, but that apply anyway. And again, that's a legal problem that's avoided when you just work through the Section 248A process. Despite all its flaws, I won't say that every small cell site goes smoothly. In fact, there's many that don't. But on the whole, reaching a solution like we did with Stowe, much easier to do through 248A.
I have a question after Mike.
Yep.
Thank you.
Selfridge?
Do you represent developers during these proceedings? Have you ever represented people on the other side of the fence and during any of these proceedings?
So two different questions. So what I would say is on the first question, our firm has represented, I would say primarily a combination of carriers. So the communications providers, power developers, right, who are often different. They're often the party that's trying to put in the infrastructure and has some kind of a relationship with a carrier. And municipalities. There's been a couple of instances where we've represented a municipality trying to put its own tower in for police purposes. And then utilities would be the other parties that we've represented on Section 248.
So have you represented people contrary to these towers going in?
No, I have not. But what I would say is I've worked with many of them, and some of them are now on the bench. Some of them we still work with. I certainly, I think Attorney Dingledine was before you. I met Attorney Dingledine being in a week-long case about a tower in Hardwick, where she was representing the town and we were representing the tower developer. So,
Thank you.
So before you get into talking about the issues with municipal permitting, we've also heard a lot about the health issues with towers. And
Sure.
when you mentioned small cells, that reminded me of that issue. And it's still where we're going to put a small cell next to what would become an apartment building. My understanding about this is that we're not only preempted from regulating cell tower locations based on health concerns by the FCC, but it would, if we did try to put something like that in statute, the first time a tower was with a location or a tower permit was denied, we'd be taken to court probably by the developer, and of course we'd have no choice but to rule that in favor of the developer that yes, Vermont's statute regarding making citing decisions based on health concerns is not allowed. It's not valid. Is that a reasonable understanding?
I think so. If I can just put a nuance on it, though,
Yeah.
It doesn't prevent what the section of the Telecommunications Act that you're referring to. I
Yeah.
think it's 47 USC 332 C7B 4, Romanet 4, if I'm close enough. What it says is that, yes, it's true, a state or local government can't set its own standard for what the health effects are. But what it can do is frequently does do is require the applicant to demonstrate that they are meeting the FCC's guidelines. And those FCC guidelines were established in 1996. It's true. So that sounds a long time ago, but they've been frequently retested and retested again and again through different administrations, Democratic and Republican, right? And with the EPA, the U.S. Department of Health, the U.S. Department of Agriculture, all having a role in working with the FCC on those standards. And then I would say, in addition to that, from my recollection, Vermont has twice looked at those standards independently. In other words, independently of any kind of citing application. One actually was a citing application, and that was the Burlington Broadcasters case that I think was decided in 2003 by the Vermont Environmental Board. There was like a couple of weeks of trials about the difference between RF interference and RF emissions. And even though the board determined that it couldn't set its own standard, it found that those standards were valid and made sense for citing applications.
The FCC standards.
The FCC standards.
Mhm.
And then I think maybe it was mentioned yesterday, then there was this 2020 report that came out from the Vermont Department of Health that also looked at that.
Yeah.
So in a typical application that we will file on behalf of a carrier or a tower developer, we will include basically what we call a maximum permissible exposure analysis, which says, based on the equipment that we're putting on the tower, where will we be in terms of that FCC safety threshold? And going off of memory, I can't think in the past 5 years of anyone where that threshold was more than about 5% of the total. So, but again, we always provide that. We get asked questions about it from time to time. Did you include the right equipment? Again, I think part of the reason why 248A makes sense is because the people who are going to know how to read those reports and see if we've done it correctly, far more likely to be the Department of Public Service than it is either a municipal zoning administrator or a district environmental commissioner coordinator.
Rep. Gutman?
Give a sense for how the US FCC health standards on RF compare to international standards, Canada or the EU or other civilized places.
I don't have a sense that they're radically different. I do see from time to time, and I'm saying this just from my own experience, not because I've looked into it closely, but from time to time, a study will emerge that says, well, we've got questions about this. But I feel like those studies never translate into regulations being adopted either at the European level or Canadian level or Australia or New Zealand. So it's not my understanding that there's been any major change in how the science of those RF emissions are viewed.
Thank you.
Yep, and then I can move to the municipal.
I'm just curious, do some towns have regulations around how far the tower can be from a home
Setbacks?
setbacks?
Yes. And I think, and I would say that I'm aware of several instances where that is the case. I've also been aware where there's cases where the setback, or at least one, I could think, I'm pretty sure it was, I don't want to impugn Cabot, but I'm pretty sure it was Cabot, and this was a long time ago, where the setback was like a very large amount. If it wasn't 2,000 feet, it might have been like 5,000 feet. And that was determined by the environmental court to be essentially a way of trying to regulate RF emissions unlawfully. So I think those types of setbacks, when they are based on an aesthetic standard, right, that's different from if they're, seem like an RF standard. And in terms of how you even would make that determination, just look at other setbacks for other types of development in the town. And if it's, radically different, then that's usually a sign.
On we go.
Okay, so municipal concern. First thing is pretty much same as Act 250, right? Municipal planning and local zoning officials, as well as the volunteers who are on development review boards or planning commissions or select boards, seldom have the experience to really be able to review and evaluate the technical aspects of an application. And we've seen many instances where when we decide, we make that decision. In this particular case, let's go to the municipality to ask for permission, and we present an application for a telecommunications facility. That official, like a zoning administrator, will say, can you please put this through section 248A instead? Because we don't have the bandwidth or the ability to look at it. We don't want to have to go hire anybody. I'll give you two specific examples of that. One was in Burlington, where for a whole bunch of reasons, the UVM Redstone water tank, right, which is interestingly enough, providing a lot of the cell service in Burlington, had to be replaced, repainted, changed on the inside, and it's got antennas all over it right now. And so we needed to do a temporary communications facility. And for all kinds of reasons, just really based on speed, it made sense to go to Burlington. And Scott Guston, who was one of the most experienced zoning administrators probably in the whole state, he was in Williston during the great build out of Williston in the zeros. He was like, please do not give this to us. Take it away, get it through section 248A. And so we did. And it was a bit of a pain, but it worked out. But I was very surprised at that reaction. The other time that this happened was actually in East Montpelier, where we were trying to site a new facility. And we looked and said, well, it may make more sense to try local zoning. And the town was adamant that, no, we want you to go through the section 248A process because we just don't have the bandwidth. So I'm always a little surprised at that. I had another case recently involving Randolph where we did apply for a local zoning permit and it caused a lot of confusion and heartburn for a whole bunch of reasons. Ultimately got approved, but it just reinforced my sense that municipalities, at least at this time, are not ready to administer these types of applications. The other concern that I have is that many of the ordinances that municipalities have throughout the state that are telecom specific were passed back in like 2000. In other words, years before the advent of the smartphone, before a kind of a major change in technology, and haven't been updated and can be very, very difficult at times to work through. Just to give you one example, in town of Lincoln, the way that their telecommunications ordinance is written requires that every application be reviewed by the zoning board of adjustment, the planning commission, and the select board, and has to be done simultaneously. So one particular application, you basically need to get 12 people to all be able to meet all at once at the same time to do the review. And coordinating that, when we did this back in, it was 2006, proved very, very difficult. And so it's not to say that your ordinances can't be updated, but even doing that takes a lot of work and imposes a big burden on a lot of the municipalities who will have any number of other things that they are trying to prioritize. I would also say that the lack of flexibility problem manifests itself with trying to do applications at the municipal level, because DRBs in particular will say, well, we can only do what's in the ordinance, and we don't have the ability to say, allow something to be shifted or changed in some way that is inconsistent with the ordinance, even where there's instances where the constituents say that would be the better result for us, right? Whether those constituents are other agencies or people who actually live in the municipalities. One of the things, again, when 248A works well that we've seen is that the municipalities are quite happy to say, here's what we think, but we're going to leave this to the PUC to decide. And we're putting our thumb on the scale of move the facility, paint the facility, try to change the location where the access road is coming from, et cetera. But not being the ultimate decision maker. Again, we've seen that there's instances in where that really helps make the process run more smoothly and alleviate some of the burden on the municipality. Timing is another issue that the municipal review process that's staffed by volunteers primarily can take much longer just because of the resources being constrained. And where that particularly becomes a problem too is that the PUC system, which has its flaws, don't get me wrong, but ultimately everything that's filed in a case you can or should be able to access as part of a case. Most municipalities don't have the ability to kind of run to basically amass comments, to make them available to the public, et cetera. There's some municipalities that obviously have very sophisticated zoning mechanisms that could do that. The Stows, the Shelburnes, the Burlingtons. But where the state needs a lot more sites, or at least doesn't have good service now, are often those municipalities that don't have that type of apparatus. I think that's probably most of the reasons that I can think of that the municipalities like Act 250 are just not ready to start re-administering this system right now. So again, my preference, both as a practitioner and frankly, just seeing how this process works as a member of the public, is to work on what's wrong with 248A, and specifically that, whatever we're calling it, the 12.5% of the cases that are not going well. And I think that the way to do that is to make sure that we get the PUC to actually focus on some type of a workshop through an order or else a rulemaking so that we can fix those parts that are not working as well as they should. And the last thing that I'll say about that is we've, especially representing AT&T is frequently, over the times that the sunset has been renewed, made an ask of the Public Utility Commission, can we start working on redefining what the submission requirements are or getting a new interpretation of this part of the statute? And the PUC has not accepted those invitations. Now, obviously, there's different leadership now, but my sense of why that has been is that the 3-year period was not long enough to allow them to do that process. So that's why I make that suggestion about if the statute is not going to be made permanent and just repealing the sunset altogether, some extra time might be the right way to go.
Rep. Civilian?
So could you provide us with a list of items that you would want the PUC to look at?
Not before 10 o'clock, but there's certainly, a lot of the things that we think about would probably be focused on the public outreach process and how that should work. Mm-hmm. And I'll just give us one specific example that there seems to have been some disagreement about when a town requests a hearing during the advance notice process, what exactly should happen? And what I would say, Representative, is that when that process works well, what happens is the parties convene, before a town select board or planning commission, or often both. The department will get involved, and there'll be a real airing of both the project so that everyone can understand what are the elements of the project, and what are the concerns with those projects, so that the applicant has time to consider making changes to that project and either coming back to the municipality to get a recommendation or deciding to go forward with a petition. I think that process could be made more clear, because as I read the statute, and again, this is just Will Dodge as practitioner, that hearing is really required in order to get the recommendation that the legislation calls for as being the key to substantial deference. The PUC seems to take a different position and say, well, it's completely optional whether you do it. But again, be that as it may, the system works well when those hearings happen. So that would be one example.
Okay, and in all seriousness, with a moment or a day or two, would you be able to provide others?
Yes, and I'd want
It would be important for the commission to look at. That would be really helpful for me, at least.
I'd be happy to do that, and would want to talk. I'd want to talk with my clients, and full disclosure, I'm not just gonna do this, riffing. But I do think that I know that yesterday, I think it was said that the carriers all love 248As and they don't want to go back to Act 250, and that's true. But again, part of it, the reason for that is because of weighing two alternatives, and not because the carriers believe, the system works perfectly right now. There's definitely improvements that can be made.
Yeah, very interested in what your clients think those improvements are. Thank you.
Rep Campbell and then Corey.
Thank you. Yeah, that's very interesting. I've been thinking also about trying to formalize that hearing process at the municipal level, and requiring public service to be part of that, not just at the request of the municipality for these projects that are de minimis, right? The other question I was thinking of, though, is you mentioned a workshop or rulemaking at the PUC. A workshop process seems like it would be much faster and also less formal, and perhaps generate better information than a rulemaking. Maybe a workshop process followed by rulemaking, if appropriate, something like that might be something worth considering. Is that
Yes. No, thank you, Representative. I would totally agree. So I wish I had the date right at the ready, but if I'm not mistaken, sometime in the fall of 2009 was the only time that the PUC had a workshop on Section 248A. And it was good because we had a lot of different stakeholders. We probably didn't have enough stakeholders, because at that point, no one was quite sure who exactly the stakeholders were going to be, because the statute had just been amended, and before that, it really wasn't being used at all. So my sense is that we're long overdue for one, and that workshop would be a faster way of at least figuring out what can be done without too much difficulty, and what things are of enough consequence that it makes sense to do either guidelines or rulemaking. So that, to me, that makes a lot of sense. But again, I think we're long overdue for one, and that, as all the testimony before this committee has proven, there's a lot to talk about at a workshop like that.
Yeah. Great, thank you.
So a lot of the cases that, go ahead, Darrell.
Please do.
Go ahead.
Okay, mine might be a little left field. You had mentioned New Hampshire. Could you just quickly tell us how it?
Oh, I'm so glad that you asked me. So in New Hampshire, there's no statewide permitting. So everything is done at just the local level. There's local zoning, and that's it. And it means that it changes town by town. Some towns are similar to others, usually they're in the same county, but for the most part, every new town is a new discovery about, well, does this go before the planning board, or does it go before the zoning board of adjustment? Different towns have different ways of approaching things like, are the zoning board members at all subject to any control by the select board, but for the most part, each entity is very independent from one another. And what tends to happen more often than not is that the zoning board and the planning board might disagree about a particular application. The difference too is that with many applications, you'll be required to get a variance. And as my one of my DRM mentors, real estate attorney Bill Schrader told me, the thing about a variance is that you can't get one, right? They're almost impossible to get. And what that ends up doing 9 times out of 10 is generating litigation that goes up into federal district court. And however expensive it is in Vermont to have attorneys involved in a 248A fight, for instance, it is 3 times or 4 times as expensive if you end up in federal district court. And I know because I was in federal district court November and December. We were there for a week litigating what's called an effective prohibition case, which is basically the denial of a variance. It's a much messier process. It ends up taking place. There's probably roughly 2 or 3 TCA cases that get filed in New Hampshire against a municipality each year. In Vermont, by my count, there's been exactly 1 over the past 20 years, and that was the ITW case that went up to the Second Circuit last year about the tower in Enosburg. So it is, I would say, on the whole, a much more litigious process there. It's not to say that it can't work, but it's messy. And it's certainly, they don't have the benefit of anything like the expertise of a Department of Public Service. And we see that again and again and again. Zoning administrators saying, how do we do this? They'll ask the New Hampshire, trying to remember the name, but basically the equivalent of VLCT over, it's the New Hampshire Municipal Association, and getting advice from them. They're helpful, but overall, it's not nearly as smooth a process.
Yeah, so a lot of the cases that you stated seem old and seem like they went through pretty easily. The stuff at least what I understood and what testimony we've heard is that a layperson in a lot of these, there's been a lot more contention. And that process, they're not getting the input they want to get into the process because they either didn't know about the 30-day advance notice and all this stuff. I think what I'm looking for is to try to make that process easier for those people to get their concerns to the PUC in a timely, not being pulled through a knothole and not costing them a fortune.
Mm-hmm.
And I'm just wondering if have you worked any of those that we've had that contentious issue?
Oh, absolutely. I think
and was it resolved?
Yeah, so I think the one that maybe you talked about a little bit was the Granville case, or you at least heard about the site in Granville. So that was one where absolutely, no other way to characterize it than it was, kind of a big fight between AT&T and several of the adjoining property owners. And a lot was done through that process. I would say in that particular process, there wasn't a knowledge issue. I think that's what you're alluding to. In other words, somebody not knowing about it or, finding out too late. People were involved from the beginning and a lot of work had to be done and it's honestly still being done to try to resolve that particular dispute, but it was resolved. And it did go to a hearing. It didn't necessarily have to, but that was an instance where there were very few alternatives. It was just a tough site, an area where you couldn't do small cells, where you had national forest on one side of the highway that you were trying to cover, state forest on the other side of the highway you were trying to cover, and very few options in terms of alternatives. So if that had happened though during Act 250, if we had done that under Act 250, there was no local zoning in Granville, so you would have just had Act 250 in that particular instance. I'm not sure that it would have been easier for any of those folks who did participate and get their voice in. If anything, what may have happened is that it could have spawned more litigation going into environmental court. And I saw that just as an example back in 2008 with the Hardwick case that I referred to earlier. That was another example of where very few alternatives, really tough situation, a lot of neighbors involved. Those neighbors were involved up until it went into litigation. And then at that point, it was very hard to participate. And that again was, an Act 250 local case. So I'm not sure that completely answers your question, except to say that I'm not really sure that 248A can't be fixed, at least to the extent there's problems on the making sure the knowledge is getting out their side. But there's always going to be disputes with, with neighbors. And sometimes, depending on the circumstances, it can be difficult.
I have a question about you had mentioned earlier that 248A is looking at sort of competing or balancing criteria, and one of those is the public good or public benefit. But what I think we're hearing, or what I think we've learned, is that the process seems to treat. I'm curious about how public benefit is defined and weighed, because in my mind, there's a really clear difference in public benefit between AT&T putting up a cell tower and ITW, which feels to me like a bad actor in this whole process. Putting up a two-way radio tower on the edge of a Class 1 wetland that's going to be for UPS drivers. I don't understand how we differentiate. It doesn't feel like there's good differentiation there right now.
Well, I don't want to impugn anybody, but what I would say is
that's okay.
Yeah, what I would say is that seems like a great workshop topic, right? In other words, to figure out what is the difference, how do you do an application that is at root tower development without, by a tower developer, where you have sort of something like, I guess it's wireless service, but not necessarily like a carrier, like an AT&T, a T-Mobile, or Verizon.
Yeah,
versus other
B2B is what we heard yesterday.
Right. But there's other parties. There's more than just that two dichotomy, right? Like, for instance, I think I mentioned that we do a lot of work for Belco. Belco has used Section 248A to permit, I would say, roughly 60 sites over the past 15 years or so that are all designed to ensure that the utility crews during an outage or, an event like we had last week can all communicate with each other with these talk groups. And so that's like another great example of using 248A for what is not cell service like that we enjoy, but that is an absolutely vital public safety system. So talking through some of the how do you figure out the public benefit does make sense. The statute as it's written right now has some differentiation from applications that are for wireless services versus ones that are for the much broader range of two-way services. So for instance, if you look at 248A-C, you'll see that for wireless services, there's what we call the co-location test. And that co-location test requires you to work through various different criteria to figure out, is there a reason why you can't co-locate on something that's in existence today versus building a new support structure, if certain criteria are met.
Rep. Southworth and then Cory.
Just, can we have Ledge Council kind of walk us through that language piece?
Yeah.
So, thank you.
Oh, I just had a question on the Belco front. Does their long-range transmission plan ever have any bearing? Because we're learning that 10-year telecommunications plan isn't really a tool in any way to assist in any kind of decision-making. And I'm used to like the comprehensive energy plan actually has a role, and I believe the transmission plan might have as well, but I'm not sure. 248 front.
To be honest, Representative, I don't know that if the 20-year plan actually mentions the radio project. If it does, I don't think it's certainly, I don't think it's centerpiece of that, except that Velco is very committed to safety and reliability, for itself and for all the DUs that it's working with. But so the answer is not to my knowledge.
Rep Howland?
So I thought I recognized your name from doing a lot of utility work over the years, and so forth. You mentioned Velco, and Velco's got some very tall poles, and sometimes if the antenna's higher, it works better. Any work on getting antennas on top of utility poles above this accounts for the public safety or the worker safety, because if you're above that energized zone, you have to have certain qualifications to maintain and work above that. So any work with any of
That, to my knowledge, that's been done a handful of times. In other words, put the communications above an existing transmission or sub-transmission line.
distribution line?
Distribution's a little different. Distribution goes into the small cells, right? In other words, that's not Velco as much as Green Mountain Power, et cetera. On the transmission, what tends to happen more is that those existing utility line corridors will be used as a way of ultimately getting to a place where you could build a separate standalone tower. And that will obviate the complications that happen with having to de-energize the line every time you want to change out antennas. I'm sure it's probably come to the committee that network upgrades, not so much for Velco, but for like the carriers, take place roughly every 3 to 4 years, just depending on when the technology is changing. But so I think that's the better for transmission. It doesn't happen very often, but for distribution, like utility poles, it happens very often. But what tends to happen is that the poles that we have in most of the rights of way today can't really accommodate the antennas unless they're replaced. It's just because they're already loaded up with things. And the way that they were built are not designed to make sure that facility is going to withstand whatever snow event or, weather event takes place. So when we do most of the small cell siting, it usually involves a pole replacement. But then that the pole's replaced, the old one's removed, the distribution lines and the fiber all go back up on that pole, and everyone's happy.
I'd like to give everybody a 5-minute break before our next testimony, unless people have a very burning question. Okay, so we'll look to thank you for your time. We'll look for your follow-up thoughts.
Sure.
That would be great. And appreciate everybody being here.